It is well known that the police do have powers to stop and search individuals and vehicles in given circumstances, but many people misunderstand what is required before the police can carry out such a search. And that's what I'm talking about today. But if you're new to me and my channel, I'm a barrister who helps you understand law, so please make sure you hit the subscribe button and the bell icon and turn on the notifications so that you don't miss anything. I also answer some of your questions on my sister channel, Black Belt Secrets, linked below. So this video is going to focus on the stop and search of a vehicle. I did another video on stop and search and your rights when you are stopped and being searched, and I've linked that in the description below as well. So first of all, a constable in uniform has the power under the Road Traffic Act 1988 to stop any motor vehicle on a road, and you are required to stop on such a request. This is often known as a 163 stop because it's under section 163 of the Road Traffic Act 1988. Upon such a stop, the police officer might ask you to produce your driving licence and insurance documents because, of course, you are required to have valid documents in order to drive a vehicle. But if you are unable to provide those documents there and then, you will be able to provide them within 7 days because this is a specified defence under that section. But what if the police officer's questions goes beyond your driving licence and insurance documents and they start talking about something that they suspect you have in your vehicle that you shouldn't have? In this scenario, it may become obvious that the police wish to search your vehicle for such an item. And this is what gives rise to much of the confusion. You see, a police officer cannot search a vehicle at random on the off chance that they will find something in the search. Broadly speaking, to conduct such a search, the constable must have what's known as reasonable grounds to suspect that they will find a stolen or prohibited article during the search. And this power to search can be found in more than one piece of legislation. For example, in Section 1 of the Police and Criminal Evidence Act 1984, commonly known as PACE, under Section 23 of the Misuse of Drugs Act 1971, also under Section 60 of the Criminal Justice and Public Order Act of 1994, and as I've referenced before, Sections 43 and 47A of the Terrorism Act 2000. And each of these sections, of course, have additional provisions or restrictions when executing a search under that particular section. For example, in Section 1 of PACE, subsection 5 reads as follows. If a vehicle is in a garden or yard occupied with and used for the purposes of a dwelling or on other land so occupied and used, a constable may not search the vehicle or anything in or on it in the exercise of the power conferred by this section, unless he has reasonable grounds for believing A, that the person in charge of the vehicle does not reside in the dwelling, and B, that the vehicle is not in the place in question with the express or implied permission of a person who resides in the dwelling. So translating that into simpler terms, if the vehicle in question is in the garden or on the driveway of the suspect's home address, or in the garden or on the driveway of another address with permission of who actually lives there, then the police officer may not search that vehicle without permission or without a warrant. Subsection 6 of Section 1 of PACE provides as follows. If in the course of such a search a constable discovers an article which he has reasonable grounds for suspecting to be a stolen or prohibited article, an article to which subsection 8A below applies, or a firework to which section 8B below applies, he may seize it. And then subsection 7 defines such a prohibited article for the purposes of this section, that being A, an offensive weapon, or B, made or adapted for use in the course of or in connection with an offence to which this subparagraph applies, or it is intended by the person having it with him for such a use by him or by some other person. And the offences that this section is talking about are burglary, theft, offences under Section 12 of the Theft Act, which is taking a vehicle without consent, commonly known as twucking. It also applies to fraud and offences of criminal damage. So broadly speaking, this means any item which is made or adapted to be or carried with the purpose to be used as an offensive weapon, or any other such item that is carried for the use by the person or by some other person to commit one of these offences. Many of you will know this as going equipped. For example, if a vehicle is stopped and searched because it's suspected of being involved in a burglary, and such a search finds a crowbar in the back of the vehicle but no other tools and no suggestion that the driver has any other tools of a work nature and that this is the sole purpose of carrying it with him, then this will be a prohibited article under this section, by way of example. Similarly, under Section 23 of the Misuse of Drugs Act 1971, a constable may search the vehicle if there's a reasonable suspicion to find any controlled drug for the purposes of that section. So those are just some of the things the police constable may be looking for, but let's take a step back a moment to before the search happens and what else is required before an officer can carry out such a search. Throughout those examples and various sections providing the powers to search, you've heard often the term reasonable grounds to suspect that the officer is going to find such a stolen or prohibited article. So what does reasonable grounds to suspect actually mean? Well, if you think of it as an officer looking at a motor vehicle without any other information whatsoever, then there cannot be any reasonable grounds to suspect that the officer is going to find any prohibited article within that vehicle. In other words, there must be more information or intelligence that provides that officer a reason to suspect that they will find something within that vehicle that is either stolen or prohibited. Take, for example, where there's been a burglary reported very nearby. Somebody saw a large estate car, red in colour, leaving the scene at high speed. This information has been relayed to the police control room and in turn relayed to the officers who have stopped the car under perhaps section 163 of the Road Traffic Act 1988. If indeed the vehicle stops, then this vehicle matches the description of that which has very recently been used in an offence nearby. The locality of the vehicle gives further rise to suspicion along with the description of the vehicle. This may well then give the officers reasonable ground to suspect that they are going to find prohibited articles in that vehicle, such as tools that are often used in burglary, such as crowbars and things of this nature. Using the same burglary example, let's say that the vehicle in question wasn't seen, but a specific person was recognised at that scene, and then the police officers are obviously looking for said person in the area following the report of the burglary. Let's say the police spot a vehicle leaving that general area at speed, even though there was no description of the vehicle given. The police officer may require that vehicle to stop, and again, if that vehicle stops and then the police officer recognises an individual within the vehicle as being someone that has been linked potentially to this offence that's just been carried out, that again may indeed give the police officer reasonable grounds to suspect that he or she will find something during a search. Let's take this one step further. Let's say that there was still a burglary taken place, but no one in particular was seen and no vehicle was seen, but there is a police car in the area whilst this report comes in. If that police vehicle then spots any random vehicle speeding away from this scene at speed, driving suspiciously, the police officer may then link this vehicle potentially to this offence. But clearly the fewer details and potential links of any vehicle to such an offence will make it more difficult for a police officer to justify reasonable grounds to suspect that they will find something to justify a search under this section. And just to be clear, in particular with respect to identifying an individual, simply relying on the appearance, race or religion of a given individual is not sufficient grounds under this section. It must be something more that particularly identifies that individual. This is very commonly the case where a suspect is known to the police and is perhaps identified at a scene and then found at large, which might give the officers reasonable grounds to suspect. However, if there hasn't been such an identification, then previous convictions by itself will not amount to reasonable grounds. Using this example where there's been a burglary and then the police officers find a known burglar in the area, the fact that he or she is a known burglar to the police, that by itself is not reasonable grounds to search that vehicle. Taking another example where perhaps the police have set up a road stop to select vehicles at random to stop under section 163 of the Road Traffic Act 1988, which they are permitted to do even at random with no suspicions whatsoever. Very frequently during such a stop, the officers may develop reasonable grounds to suspect that they might find something in the vehicle that is stolen or prohibited. This may be the case if the vehicle was stopped at random and then the police identify an individual that has been personally connected with a suspicion of committing another offence. On the other hand, it might be that the officer develops the suspicion that there is drugs in the car, perhaps by seeing something or smelling something. There's various paraphernalia connected with various types of drugs and various smells that are connected with certain types of drugs that the police officers will be familiar with, and if they develop that reasonable ground to suspect that they are going to find prohibited articles in the vehicle, in this case under section 23 of the Misuse of Drugs Act 1971, then again the police officers may detain the vehicle for the purposes of a search. And again, upon finding such prohibited articles, the police may seize them. And further, this may lead to an arrest for the possession of prohibited drugs or prohibited items, but this I will cover in more detail in another video. So by way of a broad summary, the police can stop any vehicle at random, and the vehicle is required to stop, and the driver is required to produce the driving license and insurance details, although it will be a defence if the driver produces them within 7 days. But the police officer cannot search that vehicle unless and until he or she develops or already has reasonable grounds to suspect that they will find a stolen or prohibited article within that vehicle. And sufficient grounds must come from some background information or intelligence that links that vehicle or individual to a particular crime or event that gives rise to the need for a search. Although remember, it can arise out of suspicious behaviour. For example, a vehicle being driven in a suspicious manner, or a person in the vehicle acting in a suspicious manner. And remember, during such a search you have specific rights, which I've covered in another video previously, which I will link below. So I hope that serves to clarify some confusion on when the police can search your vehicle. And in the meantime, please hit that like button, and remember, stay humble and subscribe.